Good to see you. So if you could take your seats, that would be helpful. Professor Wiseman, could you join us at the front? And while we're settling in, somebody left a cell phone out on the table, and so if you're missing it, come up at the end of this panel and collect it. So the second panel focuses on women in legal education, and for obvious reasons. We looked at Clare Dalton's life as an interesting set of moments about how women in legal education have functioned. We have three extraordinary panelists, actually, and I'm going to introduce them in the order that they will be speaking, all three of them, and then I'm going to turn it over to them to speak and then for us to have a conversation. The first speaker is Deborah Rhode. She is the Ernest McFarland Professor of Law and Director of the Stanford Center on the Legal Profession. She does her teaching and research on gender inequality and legal ethics, and is a recognized leader in both fields and an extraordinarily prolific scholar. She has served as president of the Association of American Law Schools, chair of the ABA's Commission on Women in the Profession, founding director of Stanford's Center on Ethics, a trustee of Yale University, and director of Stanford's Institute for Research on Women and Gender. After graduating from law school, she clerked in the Second Circuit for Judge Gerfine and then was also a law clerk for Justice Thurgood Marshall. She's been a visiting professor at Columbia and NYU law schools, and there's an AALS award, annual award given out called the Deborah L. Rhode Pro Bono Award, of which she was, not surprisingly, the first recipient. She also served as senior counsel to the minority members of the Judiciary Committee in the U.S. House of Representatives on presidential impeachment issues during the Clinton administration. And she is the most frequently cited scholar on legal ethics. She will be followed by Anne Shalleck, director of the Women in the Law program and Carrington Shields Scholar at American University, Washington College of Law. Anne started out on the ground at Community Legal Services in Philadelphia as both a staff attorney and supervising attorney for the Dependency Project. She founded and directs the Women in the Law program and Women in International Law program at Washington College of Law, teaches and writes in the areas of feminist jurisprudence, clinical theory, family law, and legal pedagogy. The Women in the Law program coordinates a curriculum offering specialized courses on gender and law and providing integration of gender-related issues throughout the curriculum. The program established LLM specializations as well in gender studies, created projects on integrating gender into legal education and law in Latin America and India, and works on the development of study and teaching in comparative law and on the household and global economy. Speaking third is Zipporah Wiseman, Thomas Law Centennial Professor of Law at the University of Texas School of Law at Austin. Professor Wiseman is an expert in commercial law, and she also teaches and writes on issues in feminist legal theory. So she clerked for Justice Raymond Wilkins of the Massachusetts SJC. She was a fellow of the Margaret Ingraham Bunting Institute at Radcliffe and has been a visiting professor at Harvard, the Washington College of Law at American, BC Law School, University of San Diego Institute of International and Comparative Law, and the study for the Institute for the Political Studies in Paris. Before going to the University of Texas, Professor Wiseman was a professor of law here at Northeastern, and I think there are some students of her in the room right now. She had also in Boston was a private practitioner and a public interest lawyer herself. Deborah.
Well, I join everyone in my thanks to Emily and Martha for putting this together, and Clare for being the occasion for a wonderful program and opportunity for reunion for some of us. I got to know Clare in 1985, the year that the Harvard Law School faculty failed to grant her tenure. I was visiting at Harvard at the time, and this was my first exposure to a sex discrimination claim at close range. And it's one thing to study it, it's another thing to observe it. And it was such a profoundly unsettling experience. If this could happen to someone as gifted and deserving as Clare at a place like Harvard, what did that say for the future of feminists in legal education? If there was anything redeeming about that experience, it was the opportunity to see someone surviving a discrimination case with dignity, commitments, and reputation intact. That's a very rare experience, and in these comments I want to explore why. What was typical about the challenges that our litigation posed? What was distinctive about the way she addressed them? And what does her experience, together with the experience of other discrimination claimants, tell us about the capacities and constraints of law in pursuit of social justice? So let me situate the Dalton experience in the context of litigating discrimination and lessons from the front lines, and begin by saying a few things about just the evidentiary burdens that someone in her situation confronts. As I think many of you in this room are quite aware, employment discrimination cases are extremely difficult not only to win, but even to settle on terms that can adequately compensate for the costs of complaining. Fewer than a fifth of the sex and race discrimination complaints that are filed with the Federal Equal Employment Opportunity Commission result in outcomes favorable to the complainant. Settlements in those cases are generally modest. Only 2% get to a victory at trial, and about 40% of those trial wins are only temporary. They're reversed on appeal. Lawsuits of the kind that Clare brought, which involve discrimination against lawyers or law professors, almost never produce a final judgment for the complainant. As is true in many upper-level employment discrimination cases, plaintiffs face multiple obstacles, beginning, I think, most profoundly with the mismatch between legal definitions of discrimination and the dynamics that produce it. Much of what results in our era in differential outcomes is not intentionally or demonstrably discriminatory treatment, nor does all differential treatment leave a paper trail, and colleagues with corroborating evidence are often reluctant to expose it for fear of jeopardizing their own positions. Plaintiffs like Dalton, who are denied promotion, seldom know until after discovery how closely their files compare to successful candidates. In the first employment sex discrimination case to reach the Supreme Court, the famous one brought by Ann Hopkins against Price Waterhouse, she had no information at the time she was thinking about suing that she and other women in the firm had been subjected to sex-based stereotypes. What the record subsequently revealed were comments like curt, brusque, a woman's liver, macho, overbearing, or someone who overcompensated for being a woman and needed a course in charm school. Nor did Hopkins know that several male accountants who had achieved partnership at the time she was denied had also been described as abrasive, overbearing, or cocky. No one suggested charm school for them. So too Nancy Ezold, the associate who sued the Philadelphia firm of Wolf Block for denying a partnership, learned only after discovery how her performance evaluation stacked up against male colleagues who were promoted. She'd been characterized as too assertive, too preoccupied with women's issues, too lacking in analytic ability. Yet some of the male associates who became partners had been described as not real smart, overly confrontational, very lazy, and my favorite, more sizzle than steak. Even, however, when plaintiffs can produce evidence of sex-based stereotypes and double standards, courts sometimes discount their significance. Stray remarks in the workplace can't establish liability if the defendant can demonstrate nonetheless some legitimate reason for unfavorable treatment. In one unfavorable tenure case decided the same year as Clare's denial, a female professor introduced comments describing her as too feminine, unassuming, unaggressive, unassertive, and not highly motivated for vigorous interpersonal competition. Yet both the lower and appellate courts dismissed such comments as not related to gender, but simply to the effect of the professor's personality on graduate students. Problems of proof, of course, are compounded in contexts like tenure evaluations, where ostensibly objective evaluations are obtained through a process that may be anything but objective. In the politically charged atmosphere like Harvard Law School during the 80s, assessment of scholarly merit is highly likely to depend on who's doing the assessing. Nancy Gertner, Clare's lawyer, highlighted an obvious problem in Dalton's tenure review at the time. The panel of outside reviewers that the president, Derek Bach, had appointed to consider the case consisted of no one even, as she put it, conversant with critical legal studies, the approach that Dalton's scholarship reflected. A second problem was the standard that the president asked reviewers to apply. It wasn't the one applicable at Harvard at the time, but the one they would use to assess the qualifications of someone at a leading law school. And as Clare herself later pointed out, why should the 5 male candidates up for tenure around the same time be judged by an internal standard and the sole female candidate by the universal intergalactic standard? Given these evidentiary hurdles, it should come as no surprise that individuals who perceive themselves as subject to employment discrimination seldom file formal complaints, and that's particularly true given the personal price of legal proceedings. Obviously, the costs of a discrimination case can be substantial both in financial and psychological terms. In addition to legal fees and costs, plaintiffs are putting their professional lives on trial, and the profiles that emerge are seldom entirely flattering. In listening to defense witnesses, Ann Hopkins said she felt as if my personality were being dissected like a diseased frog in the biology lab. In widely publicized cases, plaintiffs can end up like the gay associate who recently sued Sullivan and Cromwell and found himself described in New York Magazine as smarmy, a paranoid kid with a persecution complex. In Nancy Isolde's case, the Wolf Block senior partner told the American lawyer that she was like the proverbial ugly girl. Everybody says she has a great personality, but it turns out she didn't even have a great personality. Even favorable press accounts often deliver backhanded compliments that would make any potential litigant think twice. I've got a paper with a ton of them, but I'll just rest with the one of Clare by the Boston Globe. Well, she doesn't sound like some crazed feminist spouting anti-male sexual, political, or legal jargon that would allow her to be dubbed a strident female. Although many potential plaintiffs are drawn to litigation as a way of demonstrating their capabilities and restoring their reputations, the result is often the opposite. They're subject to informal blacklisting or retaliation, typecast as oversensitive or troublemakers. As one plaintiff's attorney put it, a mid or high-level lawyer who decided to sue in connection with a cutback or firing may never eat lunch in this town again, and reported cases pretty much bear that out. So what might make litigating a discrimination claim worth the risks? And what constitutes winning exactly, and can we predict it? We don't have very good data, but let me suggest 2 key questions to consider. In terms of defining winning, let's ask not just what the one-loss record was recorded on the court docket was, but to what extent did the plaintiffs get what they wanted? Were they able to use the experience to improve their lives, their institutions, or the opportunities for other potential victims of discrimination? For most of these plaintiffs, like employment discrimination complainants generally, legal outcomes fall far short of their own personal goals, vindicating reputations and compensating for losses. And the most systematic research to date finds that the factors that are most correlated with favorable monetary results don't have to do with the merits, at least as assessed by EEOC experts. The best predictors are having a lawyer, preferably a really good lawyer like Nancy Gertner, and being part of some class action or other collective mobilization effort. Clare's experience was similar to that of most discrimination plaintiffs in that it ended short of total victory. But I think what earns her a uniquely inspiring status is the way she turned difficult circumstances into the service of broader goals. From the outset, the deck was pretty much stacked against winning, either by conventional definitions or even by her own standards. What she wanted most, she told reporters at the time, was an apology. And that, she and her lawyer came to realize, she would never get. Even if she won a judgment from the state commission or had that affirmed in court, Harvard, being Harvard, would forever insist, as its lawyer stated, that there was no discrimination on the basis of gender or any other grounds. What then was the best that could come from a prolonged legal battle? Well, even if she won, what would she be going back to? What kind of a home would Harvard be if the result was accomplished by exposing all of its dirty linen and humiliating colleagues in courtroom proceedings? The school at the time was already known as the Beirut of legal education, and it's unlikely that a full dress proceeding would have done much to improve that reputation. To her enormous credit, she arrived at an alternative resolution, and the one that we celebrate today, Harvard's contribution toward a joint Northeastern Harvard Institute on domestic violence. Unlike other discrimination litigants, and my broader paper talks about many of them, Clare was not what one would call an accidental feminist who became one when her own case demanded it. Instead, she was a committed advocate for women before her litigation, and an even stronger one in its wake. At a 1987 panel sponsored by the Society for Alternative Law Teaching, she concluded her remarks with her own definition of success in cases like these. She said it's important to hang on to the idea that winning isn't everything. Waging the fight for as long as you can, knowing when to stop, and coming out of it personally intact, ready for the next venture, whatever that may be, that, seems to me, is what it means to make a success of the experience of discrimination. In thinking back on it over these years and reading through many other cases of litigants, it seems to me her case also underscores a less conventional but more satisfying way to describe winning. Plaintiffs can use their legal leverage in lots of ways: to make law, to make money, to make a point, to make change, and to remake themselves. Clare's case somehow managed to do all of the above, and I'm grateful for this opportunity to celebrate that unique and lasting achievement.
This panel, perhaps in nice contrast with the first, takes us back in history and gives us a sense of the trajectory of feminism in the period that we look at and celebrate through Clare's experience. And a critical piece of that trajectory is, I think, not primarily the trajectory of women in the academy, but the trajectory of feminism in the academy. And that's the title of this presentation, of this conference. And an enormous piece of Clare's work from her scholarship through her daily activity. So what I'm going to do is look at what Clare has taught us as she's worked with us, with so many of us in this room, about her experience and our collective experience as feminists challenging the world of legal education. Clare's work spans more than 30 years, which is a period of monumental change within legal education. Feminism and feminists, since feminism wouldn't exist without feminists, began that period as critical to a multifaceted assault on what was at that time a totally self-satisfied, intransigent, sclerotic, intellectually rigidified institution. From critical legal studies, through clinical education, through critical race studies, we collectively have, if not transformed it, seriously shaken it up during that period, so that we now have a dynamic, engaged site for understanding how law in theory and law in action shape our world and reflect our world. The first panel is a nice example of what we have collectively created through our work. So Clare's work as a scholar, a teacher, an activist has inhabited through the years several sites for bringing this about, and I'll just mention three. The first is just her appearance in legal education. Now, many of you in this room are not old enough to realize what the significance of that was at the time that it happened, but to have a feminist appear as a law teacher, as an academic, she was not the first, but it remained a period of where it was great power, where it was very powerful to us. Now, I knew her as someone who came after her, and I started in 1984, and at that moment, Clare appeared as established, respected, a senior figure. To think about that now, when senior perhaps means something different to us. And it reminds us that in a period of rapid change, generations move very quickly. So that Clare, for me, was somebody to whom I looked up to and could learn an enormous amount just by being there. But she was present not just as an extraordinary, exceptional woman. She was present as a feminist who identified herself in that way, and that made all the difference. She embraced the task of shaping what feminism meant in law, and she embraced it fearlessly and accepted the consequences of it in, as Deborah described, incredibly creative ways. She reached out to help other women navigate their ways through a hostile world and to help them identify as feminists and to be brave themselves in that endeavor. And she saw herself as part of a collective project, not an individual project, of transforming legal thought, legal institutions, legal practice, and the communities in which law gains its meaning. In Clare's own writing, she's emphasized this important and critical difference of women entering these bastions and how they understand themselves. Entering and pursuing the profession here, the profession of law teaching, not primarily as an individual woman who in the end can rely on her hard work, her intelligence, and her merit, but as a feminist who relies on and contributes to that collective project of transforming the world through her own participation. Again, as Deborah's paper gives us a nice example of. So her first sight was just entering as a feminist and identifying and standing there that way. Second, once she appeared as a feminist, she used her scholarship as a site to create feminist thought in law. And Emily began us with her the beginning of her amazing article. So that's how it was. She challenged law and the legal subject as universal and abstract. She began and worked from the situated understanding of the experiences of women and of her own experience, people with particular visions, particular experiences, and particular histories. And so with that work, she helped all of us confront the weight of authority that resisted these challenges. We used her concepts, her tools, her analyses, as Lisa said, up till today we use them. We read her, we listened to her, and she helped us reshape our own meaning in the world. But then, had legal feminism been just about creating great scholarship, it would have been probably a little more than a blip in intellectual history. She embedded her work in changing the whole legal academy. One of my small connections to Clare's choice about how to lead her life was the 15 years that the Women in the Law program that I did a program on women's rights in the law school curriculum. And the entire credit for that concept goes to Liz Schneider, who's in this room. I remember the day that we came up with the name for that 15 years of work that we did. And the goal was to instantiate feminism in the daily experience of legal education, recognizing what a powerful institution that it is, and the importance of changing that institution in the ways that we create and transmit legal thought through the curriculum, through our courses, and through our daily practices of teaching. And Clare remained, in my efforts to contribute to that, a key central participant from our very first conference, where we looked at the core curriculum and what was defined as the core. And we found at that moment there was not a single textbook used in a single course at that moment in history that had a woman as a co-author. That had feminism and feminist concepts integrated within it. So that is the world that Clare entered as an expert in transforming contract doctrine at that moment. And so she was working to catalyze feminist thought and critique as foundational and not marginal within the academy. At a later conference, she approached this task in a different way, and that one was about approaching teaching about the battering of women, women's experiences, legal responses, and the educational project. And that approached the legal academy from the site of women's experiences, not from the site of the core curriculum. And then spreading that thought throughout the curriculum. And so at that point, Clare was again critical in thinking about how you take those experiences, the daily experience of women, with battering and with the law, and make it part of legal education throughout it, from specialized courses through integration into almost every aspect of the legal curriculum in which battering needs to be addressed. And then finally, the development of the Domestic Violence Institute here at Northeastern that crossed barriers in yet another way within the academy to create a clinical program of experience in which students experience what this is like to take the law and work with it in its many, many forms and incarnations, and to reflect on that, to be critical of it, to look at legal institutions and how they work on a daily way, what the law means in the world as it is lived, to look at the lives of women who experience the violence and the effects on the communities in which women live, from the most local sense of community, again through, as our first panel showed us, the most international. And also the ways it embodies, the Institute embodies research and collaboration across disciplines to take law out of its segmented place in looking at social life. So what Clare, with Lois and others here, have created a site in legal education to create a complex, nuanced, grounded, expansive understanding of how law operates in the world. Something she was trying to do with contract doctrine back at the very beginning, but in a very different way. And so she's created an institution that in its existence and in its practices transforms our understanding of law and life. So what we can see in all of this is a trajectory of feminism in the academy and a trajectory of feminists in the academy, as we all continue to work together to create, to transform, and develop sites for building our knowledge collectively, and then for taking on the deep ethical and exciting project of educating students about these new meanings and new understandings of law that have embedded within them feminism and feminist understanding of the world.
Well, it's sort of shocking to think of Clare as a senior. I don't know what that makes me. I'm so pleased to be here, to be a participant in this symposium and part of this panel. It's a return to the place where I hesitantly began my teaching career almost 40 years ago, quite unsure whether it would be possible to combine two jobs, that of a very engaged mother of two young boys and a teacher of law students, a terrain of which I was entirely ignorant. There was one woman on the faculty at Northeastern Law School when I came, Judy Brown, and if I was permitted to join the boys' club, I would be the second. I was terrified when the most aggressively left-wing member of the faculty, left-wing and counterculture member of the faculty, he taught in wearing overalls, asked me quite aggressively in my interview whether I was sure I had made adequate arrangements for the care of my sons when I was working. He made it clear that in his view, it was a most irregular idea I had that I could join the boys' club. And the other reason that I'm so pleased to be here is because today's proceedings are in honor of the career of Clare Dalton, a woman I came to know as a member of the august Harvard Law School faculty. I visited there for 3 years as a visiting professor during the time that Clare was going through this debacle. Harvard Law School was referred to in my family ever after as Valhalla. the home of the gods, as they saw themselves. And I shared with Clare a clear and radicalizing experience of the glass ceiling as it existed 25 years ago. I guess then it would be wrong to call it a glass ceiling. It was more made of lead, I think, in that time. I admired Clare greatly during those 3 years. One year of which I was joined by Deborah as a visiting professor and Peggy Radin. And I admired Clare because, to use the wonderful cliche, she never failed to speak truth to power in any, either publicly or within the faculty, and they sure didn't like it, and they sure didn't like her for doing that. I also admired her because of the shoes she wore. Her shoes were so often red or green or purple, which was, now it's not shocking at all, but then. And I loved the shoes both for their aesthetic value and because I saw them as another finger to the men around. There were 5 women on the permanent faculty of 65 at that time, and their comfort level at Valhalla was best brought home to me by a wonderful incident. It was during the year Deborah was there too. There were 2 of the 5 permanent members of the faculty whose first names were Martha Field and Martha Minnow, both women with dark hair, brown eyes, one fairly short, one pretty tall. And another of the women was Kathleen Sullivan, who more resembled a Valkyrie than. And one day in the hall, just outside the area where my office was, one of the senior gods greeted Kathleen saying, "Hello, Martha." And we decided the following week during a dinner at my house, we had several dinners in those days as support and comfort. We decided that for the coming month, whenever we were in public, we would address, and ran into one or the other of us, we would address each other as Martha. And I don't think The Handmaid's Tale had even been written in that. It was wonderful. Our Harvard careers ended at the same time, with Clare famously being denied tenure, as Deborah has so well described. Her tenure on the faculty level was decided at a faculty meeting in which one member of the faculty went through each of her many footnotes. I don't know how many there were, 200 I think in some, in her long piece, which was heading for a book at that time, on Rylance v. Fletcher. And he went through them and related to the faculty his research on her research, demonstrating their inaccuracy. Several members of the faculty have told me then and later that they had never had such a discussion before of anyone's scholarship when they came up for tenure. And it was special treatment, I guess it would be called, right? Clare's response to this was a paradigm of feminist practice, as Deborah has already given you the details of, as indeed her life since then has been. She sued Harvard Law School for discrimination, and with her able counsel now, Judge Gertner, who's happily among us, who represented her before the Massachusetts Commission Against Discrimination. And Harvard was represented, all these circles close, don't they, by the recently retired Chief Justice of the Supreme Judicial Court. Clare decided to accept Harvard's offer of settlement, which I was just told yesterday was because they didn't want to rip the faculty apart. I just loved that. And I said, well, what do you mean? And the gentleman said to me, well, there would have been, the members of the faculty would have been divided and would have testified against each other. That's unthinkable. But what Clare asked for in the settlement, and that's the second aspect which makes it a paradigm of feminist practice, was that the money be given to Northeastern, where she was already teaching here, to establish a domestic violence institute. I've always thought of it, forgive me for making it so particularized and personal, but I've always thought of it as a testament to the violence she had just suffered. The violence of the dominance of Valhalla and the men in it. My failure to be appointed to Valhalla, also by a vote or two, led me to accepting a chair at the University of Texas Law School, which was initiated, I believe, by a longtime visitor at this law school, Barbara Aldave. And in my first year there, as a visitor at Texas, I taught commercial law, which was then my expertise, but I also taught a seminar on feminism in film, I think I called it. I forgot what I called it. I assigned a film a week in which was centered on a woman. These were feature films, centered on a woman. At the same time, I assigned an article on feminist theory, which was relevant to the film. I learned later that my not yet permanent colleagues at University of Texas referred to it, we met in the late afternoon, referred to it as Zipporah's Nights at the Movies. That was the regard with which they held it. There were 4 women on the faculty at the University of Texas, and a faculty of 65 at that time when I came, one of whom was Professor Aldave. And so it was, it was pretty much the way Harvard was in that sense, and in many other senses, I must say. There's another story I must tell. In that seminar, I assigned Spike Lee's film, She's Gotta Have It. It was his first film. I don't know how many people have seen it. It has a graphic, a graphic number of frames of sexual intercourse, as well as many other terrific things. And one of the people who took, there were two of the women faculty of Texas who took the seminar. And one of them had rented, because there was no Netflix, there was no Blockbuster, she rented a VHS of She's Gotta Have It to watch during spring break. And her grandmother was visiting. And she invited her grandmother to watch the film. Grandmother was, I think, 87 at the time. And so I said, she came to the first meeting still laughing. It was Alexander. And I said, well, what did your grandmother say? And she said, well, there was a long silence at the end. And then she said to me, honey, is this what they teach at law school now?
Yes.
A few years after the debacle at Valhalla, Clare published in the Berkeley Women's Law Journal, and I was surprised when I looked back that there was already a women's law journal at Berkeley, because there were very few women's law journals at the time. I think there are now 35. But Clare published a short but pungent article called Where We Stand, Observations on the Situation of Feminist Thought. To go back and read it now as I did was an amazing experience. Since the published literature at that time on feminist thought was, minuscule, and it was being written by very few women, whose names can be counted really on the fingers of one hand. In that article, she called for not only a focus on the treatment of women, of women's realities, of women's lives, and concerns in legal education and the legal profession, but she called for a negotiation of new relationships between men and women and new imageries to instantiate and celebrate them. At the end of the article, and this was 1989, I think, 87 or 89, I'm not sure which, she ended with a long quote from, I guess, what you could call the manifesto of the 20th century wave of feminism, and that was Virginia Woolf's A Room of Her Own. And she ended by calling for feminists to not replace the grand male absolute theories that we all studied for 3 serious years of our law school career as students, but to displace was the word she used, to displace those theories and invent ones of our own. I think in the last many years since that was written, she has done that, as have many, many of you in this room. And I think that's a reason for disagreeing with some of the pessimism she ended the article with. I think that, and as Anne referred to, This first panel is an indication of how broad that change has become. And I think there's reason to be optimistic for the future. Lots of things I didn't say.
So, comments, questions, thoughts? I think Martha's got the mic.
Damn, I'm going to have to go back and read some of what I've written. In other ways, I find the portrait that is building of me today quite unrecognizable. I wanted to say a couple of things. First of all, that a part of my survival of the experience at Valhalla was the very warm welcome that I received here at Northeastern, where I think for the first time professionally I felt at home. And that feeling didn't diminish over my years here. The second thing I wanted to say is that Zipporah did not acknowledge that she played a very critical part in the settlement process with Harvard. We reached a point where the numbers had been agreed on, and it seemed as if the shuttle diplomacy that was taking place in 2 separate rooms at the Charles Hotel was going to resolve nicely. And then in the last minute, Harvard offered a press release that they wanted us to sign on to. And the press release said nothing about a legal claim or a settlement. It simply said that this was a grand opportunity for Harvard to step up to the plate and invest some resources in domestic violence, which they recognized as a pressing issue. And then we took a break, and I really felt that this was over, that I couldn't sign on to any such statement, and that the settlement would fall apart, and that we would then have to prepare for a hearing, which would have taxed Nancy even more than me, but was not something to look forward to. And I called Zipporah, and I said, I can't do this. What should I do? And Zipporah said, well, you don't have to sign their press release. Why don't you write another one? And, it was just, it was like, oh, well, wake up. And so Nancy and I crafted another one, and I really had no hope that the folk on the other side were going to sign it, but it talked about the settlement. And they accepted it and signed it. So Zipporah deserves a lot of credit for that, just that final critical moment.
I wasn't going to tell that story, because it's your story, but I remember that call so clearly, and it meant so much to me, because it acknowledged what I had experienced there, and the closeness of the relationship we had developed over it.
Mm. And then finally, I just want to show you that while I may still in some ways be as radical as I ever was, my shoes have gotten less colorful.
Hard at trying to change the professional institutions in which our students are going to live their lives.